Hey folks, today I'm going to talk about one of my favorite subjects of my entire career that I've been really involved with and deeply passionate about. And that is positioning folks who are entrepreneurs to succeed in self-petition applications. Now, I'm going to hone in a little bit today on tech entrepreneurs specifically, because I feel like more than any others, they tend to be sort of stuck in a no man's land as it relates to the various immigration, classifications and benefits that are out there and how they can leverage it. Now, those of you who are in the tech space, you need to understand that there are two major self-petition options in the employment-based categories. That is an EB2 national interest waiver. So that's a second category visa, and it's not always immediately available for a green card. So, and we've talked about this a lot. You can check out our other content that talks about national interest waiver and how it applies to different professions, including entrepreneurship. Today, what we're going to be talking about is that EB1 category, the very exclusive first category of individuals with extraordinary ability, and how their cases can be leveraged in the context of an entrepreneur related case. So when I think about tech entrepreneurs for EB1a, I tend to think about folks that might be in maybe 2 or 3 possible categories, generally speaking. You may be an individual who is outside of the United States, or you travel frequently to the United States. However, your business and your operations are mostly based outside of the US, right? So you have the individual who is outside of the United States. They could be in the subcontinent, they could be in the Gulf, they could be in Europe, South America, Central America. There's a lot of tech, definitely Canada. There are many tech entrepreneurs who are interacting greatly and find a lot of benefit in having a foothold in the US, but they're not really, they don't have their, the nucleus of their operation is not yet based in the United States. So that's one category of folks. And then you have individuals who are in the US who have an entrepreneurial intent, yet because of limitations on visa eligibility, they are working for a company. So this is probably the largest group of individuals who are seeking an immigration benefit to sort of change the circumstances of their situation. But yeah, these folks are definitely at major technology companies, yet they have their own, startup concept, and they're wondering, how can we leverage it in order to position ourselves to really pursue these aims. And then the third category, they've kind of taken one step toward that entrepreneurial pursuit, or they are maybe working within a smaller group on an O1A visa. An O1A visa is a non-immigrant status that is enjoyed by individuals who have demonstrated extraordinary ability, but only in the non-immigrant category, where it's a little bit easier and they don't yet have the sort of idea of how to pursue their EB1a case. So those are the 3 sort of categories of individuals: the external entrepreneur whose company's nucleus is outside of the US, the person who's has an entrepreneurial intent but is working at a different company due to immigration limitations, and the individual who's sort of starting out their entrepreneurial pursuit on an O1A visa. So for the individual who's outside of the United States, and basically everybody that's even in the United States, you need to understand that the requirements for EB1a are the same. There's one set of requirements that are specific for EB1a extraordinary ability, and they apply to everyone. So I'm just going to quickly run through those. Now, if you look at the USCIS website, if you Google information about EB1a, you're going to see that basically, there's 10 regulatory criteria that you need to demonstrate a minimum, and you need to demonstrate a minimum of 3 of those 10 criteria. And then there's a final merits determination, which is to holistically look at your case and make a determination that you're among the top percentage of professionals within your area of endeavor. Now, that is very surface level, superficial in terms of what is actually needed in order to pursue an EB1a. In reality, there's an actual statute that governs EB1a. And what that statute talks about is, number one, that you are going to demonstrate what's called prospective benefit, future benefit to the United States. Secondly, that you have already achieved a claim, sustained a claim that is recognized in your particular area of endeavor. And thirdly, that you will continue to work in your field of endeavor, right? So the language that we look for as it relates to technology entrepreneur is understanding what your specified area of endeavor is. What is the specified area where you are seeking classification as an individual of extraordinary ability? Essentially, what is your superpower? And I think that technology entrepreneurs in particular understand this concept better than anyone. And they're able to articulate and sell themselves. You've already sold yourself to investors. You've sold yourself and your product to other companies. Therefore, you will be best suited to be able to sell your own credentials, your own abilities, your own past achievements to a USCIS adjudicator. So those are some of the intrinsic qualities that create an advantage to individuals who are technology entrepreneurs that might not be present with, for example, a scientist who is, super smart, super able to solve these, philosophical, scientific problems, but they may not be as well positioned to sort of brag about themselves or have a high level of confidence in approaching others in order to have those individuals, provide testimony, for example, as such. So just the kind of quality that exists with regard to entrepreneurial pursuits, leveraging those qualities will, in a self-petition application, has intrinsic benefit. So I think that you, as an entrepreneur, will benefit greatly from that pursuit. So that individual, what you need to really focus upon is, number one, that you have original business-related contributions that you have already made, and that those business-related contributions have made a significant impact within your claimed area of expertise. And this is super important from an EB1a perspective, because not all of the criteria are created equal, meaning different criteria within the context of the EB1a apply at different levels to different people. So, for example, one who is an artist, they, in their pursuit of an EB1a, right? Because you could pursue EB1a as an artist, as an athlete, as an educator, as a scientist, scholar, or a business-related pursuit. So there is a vertical that is specific to business cases. But when you're pursuing EB1a as an artist, the most important thing that you need to demonstrate is whether your artwork has been showcased in an artistic exhibition. That's a regulatory criteria that exists under EB1a. Of course, that criteria does not matter to a technology entrepreneur. We don't give a damn that you have not provided artistic work to an exhibition. It has nothing to do with your pursuit. I would say the same thing as relates to publications. We don't care whether or not you've published work. generally speaking. I mean, if you have, maybe we could leverage it, we'll figure it out. But a real entrepreneur isn't going to waste his time or her time publishing articles in, sort of obscure journals that nobody reads. That's not the kind of thing that a technology entrepreneur spends their time doing. The thing that an entrepreneur spends their time doing is making business contributions that are significant. And the way that you measure significance is going to depend upon the kind of contribution we're talking about. And one of the most important things that we want to look for here is whether your contribution has transcended your organization. Meaning, do others within your field, within the area of your claimed focused contribution area, do others in that area know about you and the work that you have done? Because that's going to be a measuring stick for EB1a. Now, we've done a lot of research on this. We've read all the case law. We know exactly what factors to pursue. All of that material can be shared in a kind of strategy session. So those of you who are looking to take the next step in pursuing your EB1a as an entrepreneur, we're glad to have those conversations with you. But just understand that if you want to succeed, what you need to do is focus on the areas of strength that you have. So as a business related contributor, as an entrepreneur, the most important regulatory criteria is going to be original business related contributions of major significance. I cannot believe that people don't realize this. It's so obvious to me, at least, but I guess to other people, it's not so obvious. They like to spend years and years publishing work instead of, presenting their business related contributions. That doesn't make sense. The second important area would be performance in a critical role for a distinguished organization. So if you're outside of the US and you've established a business and it is distinguished within your field, clearly as the proprietor, as the entrepreneur, as the tech entrepreneur who started this business, you have a great argument to make for critical or leading role. That's going to be really fundamentally important. The third area that I think is going to be super important, if not the most important, but super important, is going to be to demonstrate that you command a high salary or other remuneration. This is so important because you have the ability as an entrepreneur to use things like investment in your company as evidence of remuneration. You can also show, for example, that term sheets, valuation of your company. So if, for example, you've grown the company to a certain point, however, you're bootstrapping it, so you're not paying yourself much, the valuation of your company in a term sheet that was used for purposes of investment and the relative ownership that you hold in that company is a measurement of earnings, of remuneration that you have built and you can leverage for the purpose of establishing your high salary, high remuneration category. So this is super, super important. You want to make sure that you're able to do this. We take a really sophisticated approach to make sure that salary and remuneration is, argued and presented in the very best light. I strongly, strongly encourage those who have unorthodox ways of payment or compensation as such to reach out and allow us an opportunity to analyze it, because there are ways to figure out how to pursue this. So those are the three fundamental areas that you want to consider. Now, I want to shift a little bit away from the regulatory criteria and such to talk a bit strategy now. So for those of you who are already in the United States, let's say, you know what, I've been making, $500,000 a year at Google and I'm just, kind of sick of it, or, and I want to do my own thing now. There is a way to do that. We can hold your hand and take you on that path. So if you have a pursuit that you want to engage, but the only thing holding you back is your immigration status, and you're a high performing professional in the technology space. So essentially, you are a tech entrepreneur who's not really able to pursue their dream because they are constrained by their immigration status. We know how to get you out of that situation and pull you away from the scenario where you're constrained by your employer, and even use your own organization to self-petition for you. So there is a way out of this scenario, and we can definitely guide you and take you to that path of pursuing your entrepreneurial startup concept. The third category of individuals, those who are on an O1A and might be working at a smaller firm or maybe established their own firm. Now that you have that O1A already established, it is considered to be a sort of first step. It does create a standard that you have already met. So there is a presumption under the law that one who has already received an O1A can also pursue EB1a. And where the adjudicator in the EB1a case disagrees with the prior O1A case, they have to present a very thorough analysis as to why they are disagreeing with the previous O1A adjudicator. And practically speaking, what that does is it creates a scenario where adjudicators do not want to disagree with previous adjudicators in an O1A, or EB1A adjudicators do not want to disagree with the previous O1A adjudicator, because it's going to be a hell of a lot of work for them to have to analyze why they are disagreeing. So those individuals who are on an O1A, there's a way that we could also position you to get an EB1A approval based on all of your achievements, but also based on having already received recognition of extraordinary ability under the O1A category. So these are really, really important ways for technology-related entrepreneurs to pursue a green card through EB1A, through upgrading their O1A to EB1A, and also leveraging their entrepreneurial mindset and qualities to meet the regulatory requirements. Thank you guys so much for listening. I hope that this is informative, can help you out, and we're glad to work with you and roll up our sleeves to make this happen.